Hi, everyone. We're just going to give it a couple of minutes here for people to trickle in, and then we're going to get started. All right, so I think we can get going now, and whoever wants to join will join afterwards. Welcome to Spotlight on Solitary, which is a 2-week project featuring daily events on segregation and solitary confinement with experts in imprisonment and prison law in Canada and abroad. My name is Adelina Iften. I'm a law professor at Allard School of Law, Dalhousie University, and I'm going to be the host for today's event. I'm joined by Professor Debra Parkes from Allard School of Law at UBC and Professor Lisa Kerr from the Faculty of Law at Queen's University, both of whom are experts in prison law, so we're delighted to have them here. Today's event focuses on the international and constitutional rights of incarcerated individuals, especially as they relate to solitary confinement. How the event today is structured, I will be providing an overview of the main international frameworks and principles that govern prisoners' rights generally, solitary confinement in particular, and to which instruments to which Canada is signatory or has committed to implementing. And that will help provide some context to Canada's practices around segregation and practices that you will hear about for the duration of these 2 weeks of Spotlight on Solitary Confinement. Then Lisa and Debra are going to talk specifically about 2 cases, 2 charter cases that have been defining in terms of solitary confinement in Canada and constitutional principles around it. Deb is going to talk about the BCCLA case in British Columbia, and Lisa is going to talk about the CCLA case in Ontario. Now, just a housekeeping issue. We will have some time for questions at the end. I do encourage you to use the Q&A function that you're going to see at the bottom of the screen. Please feel free to type any questions that you have during the talks, at the end of the talks, whenever you want. And once we're all done, I will read the questions out loud and I will put them to the speakers. Okay, so I guess without further ado, I'm first to talk, and I'm going to just share the screen here with you. 1 second. All right, so I will try and cover quite a bit of the international frameworks that are of particular relevance. And you are going to see here in green, I have noted the conventions. The conventions are the ones that are binding. Canada is signatory to all of these conventions. The documents that are in blue are sets of rules that are not considered binding on the states, but Canada has committed itself to implementing them. And that's particularly true for the Mandela Rules, which I am going to be focusing on today. Now, the rules are very important because a lot of times they help interpret some of the rights that are being noted in the conventions, and they also provide quite a lot of context on what the states who are part of the UN have to do to implement them. Now, it's important to note that all of these instruments set limits to what the state can do to an individual, whether the individual is free or in custody, and they guarantee the right to the highest attainable standard of physical and mental health, as well as the right to be free from torture and inhumane treatment or punishment. Now, some conventions, as you're going to see there in green, are specific to groups of people, and they just pertain to their rights more broadly, like for the rights of the child or the rights of the persons with disability, and also have some provisions related to incarceration. Now, all of the set of rules that you see in blue acknowledge that solitary confinement can amount to torture in certain circumstances. and the basics of when solitary confinement and what solitary confinement is in the international arena is best explained in the Mandela Rules. So that's why I'm going to focus a bit on that. Now, for those of you who don't know or are less familiar with the Mandela Rules, these are an updated version of the 1955 standard minimum rules for the treatment of prisoners. And they were adopted unanimous, I should add, in December 2015 by the UN General Assembly. And what they do is essentially they set out minimum standards for prison management, including the upholding of prisoners' rights. The first 5 rules set the basic principles that are applicable, including the fact that torture and any other form of ill treatment is prohibited. Rules 43 to 46 deal very specifically to solitary confinement. And here's the part that's very important, I would say, is the definition of what solitary confinement is. And the Mandela Rules define solitary confinement as confinement of 22 hours or more a day without any meaningful human contact. This is the most common definition of solitary confinement. Is not the only definition, but is the most common. And definitely we'll see that Canada has adopted parts of it. We can see traces of that in its jurisprudence and sometimes even in the legislation. A couple of things that I do want to point out regarding this seemingly straightforward definition. One of those things is that it's becoming clear the moment when you define solitary confinement as they did, holding somebody for 22 hours or more, that solitary confinement is a practice. Solitary confinement is a way of doing things. And that's important because our legislation in Canada historically has tended to define solitary confinement as a place, whether it's administrative segregation or disciplinary segregation. So basically a place where you write on top segregation or solitary confinement. And that's our general understanding of what it is. It comes from these pieces of legislation or national pieces of legislation. But that is not how the international rules are defining it. Basically, in accordance to this idea that solitary confinement is a practice, it means that if you are locked up in a cell on your range, or you are placed under suicide watch, or you are placed in mental health isolation, or you are placed in a dry cell, or a quarantine, or a structured intervention unit for 22 hours or more in a day without meaningful human contact, then you are essentially experiencing solitary confinement. The reason why you have been placed there, you've been kept there, is also irrelevant from an international standpoint. And I really do encourage you to listen to yesterday's event on solitary in the Maritimes, because the speakers did describe a lot of solitary confinement practices that fall outside the legislated close confinement definition in the province. So it gives you an idea of the range of that solitary confinement, the shapes that solitary confinement can take. So the idea is that if it fits this description, that means that the rule that pertain to the regulation of solitary confinement apply no matter how you call them, or should apply no matter how you call them. And what are those rules that govern solitary confinement? Here we have Rule 43 that's setting some of them up. And the general idea here is that whenever solitary confinement reaches the point that it's torturous or inhumane, by the Mandela Rules definition, then it is strictly prohibited. So there can be no real exceptions to any of this. And those are 3 main situations according to this rule, which are indefinite solitary confinement, prolonged solitary confinement, which means more than 15 consecutive days, or placement of a prisoner in a dark or constantly lit cell. Now, it's interesting to see that you're going to hear both Debra and Lisa talking about the recent charter cases. You're going to see that both courts have adopted some of these criteria into their rulings. For instance, the BCCA court has, the BC Court of Appeal has prohibited the indefinite solitary confinement or prolonged solitary confinement. The Ontario Court of Appeal has put a hard cap on solitary confinement of no more than 15 days. So we see sort of traces of international rules in those decisions. Unfortunately, as you're probably going to hear for the next 2 weeks, all of these practices continue to exist in Canada, both at federal and provincial levels. Again, remember that if we define solitary confinement as a practice, then it doesn't matter what we call it. And if keeping somebody for 22 hours or more falls under indefinite, prolonged, or in a dark cell, then it should absolutely be prohibited. Now, the other thing, of course, there are many examples of prolonged or indefinite, but there are also, unfortunately, examples of placing people in a constantly lit cell. I remind you of the example of Adam Capet a couple of years ago in a provincial prison in Ontario. He was found there after spending some 200 days in a constantly lit segregation room. So these things are not last century, they do exist. A couple other rules. The Mandela Rules are very clear that solitary confinement should be a last resort mechanism, and it includes a requirement that an independent decision maker reviews the decision to place somebody in a solitary confinement. Now, I should note the fact that provincially we do not have any form of solitary confinement in most provinces. There aren't any independent decision maker in Canada. Federally, there also weren't any for the old solitary confinement regime. For the current, I guess, structured intervention units, which they say is not solitary confinement, there are some independent decision makers, but only for when the placement in structured intervention units is above 15 days, whereas the Mandela Rules require it immediately. And then the other prohibition is on placing in a solitary confinement-like situation any women who are pregnant, who are breastfeeding, or who are having infants, and to seriously restrict the use of solitary confinement on prisoners with mental or physical disabilities. Again, we see traces of this in some of the recent Canadian decisions. The BC Court of Appeal basically prohibited the use of solitary confinement on people with mental or physical disabilities. Again, practices like this exist in Canada. They are not unheard of. In my own work with people with disabilities, I see them placed in various forms of protective custody or any other forms of lockup, either for their own protection or because they are concerned that they will misbehave. People with mental disabilities, they are extensively placed in mental health isolation. As you're going to hear next week, they are extensively placed in structured intervention units that in certain situations have amounted to solitary confinement, as you're going to hear next week. So we do see examples of that quite extensively. We also see examples, especially provincially, of women that have been placed in a segregation and were pregnant. The case of Bianca Mercer in Nova Scotia, she was 24 weeks pregnant when she was placed in a continuously lit cell, and she slept on the floor of the segregation room. So unfortunately, a lot of examples that are in flagrant violation of international guidelines. The final point that I want to make is that there are also some obligations that are applicable to individuals who are working as medical personnel in prisons. There is an obligation for them not to be involved in any capacity in the decision-making, solitary confinement decision-making. So they would not be allowed to, for instance, check a prisoner and confirm that they are in good health and hence can be placed in solitary confinement. That is unethical and not permissible, but they should be going and visiting people in solitary confinement every day, any form of solitary confinement. And that's not really something that happens on a systematic basis in Canada at all. I'm going to conclude by pointing out two things. One of them is that these international instruments are not enforceable in Canada directly. That's how international law works in Canada, but Canada is bound by the conventions to which it is signatory and has formally committed to the implementations of the Mandela Rules specifically. The second point that I'm going to end on is the fact that these international instruments prescribe minimum rules, not maximum rules. So these are rules that are meant for all countries, irrespective of their level of economic development or standard of implementation of human rights. And one would think that the better off economically a country is, and the more it champions human rights, the likelier that these rules will not just be respected to a T, but they will in fact be surpassed, right? So I will end there and encourage you to attend the future events and consider, when you hear about the various practices that Canada is involved in, consider how all of these international rules are implemented, and what does that say about Canada's commitment to these international rules. Okay, so I'm going to stop sharing now, and I'm going to stop there, and I'm happy to take any questions if you're going to have at the end. But now we are going to move on to Professor Debra Parkes, who is going to be talking about the BCCLA case.
Thank you, Adelina. It is just a real pleasure and privilege to be part of this, this discussion today. I also want to thank all the organizing groups. I know there's a number: Prisoners Legal Services. I hope I get everybody: Canadian Association of Elizabeth Fry Societies, John Howard Society of Canada, and the Schulich School of Law. If I've missed any organizations, please let me know later. But it's a terrific set of events going on, and I urge you to attend the other ones as well. I want to begin by acknowledging that I am coming to you from the unceded, ancestral, and traditional lands of the Coast Salish peoples. I am in the city of New Westminster, British Columbia, which is the unceded land of the Kakite First Nation. UBC, where I work and where I live in this area, is on the unceded lands of the Musqueam, the Squamish, and the Tsleil-Waututh First Nations. And in turning my mind to a land acknowledgement at the beginning of a talk like this, I do that intentionally to orient myself to thinking about, in all that I do, in talking about imprisonment and the way that we might use law to address some of the harms of incarceration, is to kind of be constantly aware of the way in which colonial laws have facilitated and perpetrated violence against Indigenous people through dispossession and through a whole range of legal forms, and currently enacting state violence through incarceration. By way of my overview of comments today, I'll focus on the, as Adelina said, the groundbreaking decision here in British Columbia, first at the trial level and then at the BC Court of Appeal level, in a constitutional challenge brought by the BC Civil Liberties Association and the John Howard Society of Canada. It's a decision that found the administrative segregation regime to be unconstitutional in a whole range of respects. I'll talk about the parties, the claims, the findings. We'll get a little into the weeds a little bit, so because I think what's important to understand about the case is what kind of goes forward from that case now that we have this new regime, right? And the old regime has been replaced. But that there are a whole range of ways that the findings and legal and factual findings from there, I think, have a lot to say and can be used in challenging current practices. And then I'll just share 3 thoughts that I have about the future of charter-based advocacy in relation to solitary confinement in all its forms. I also, just before I move forward, want to acknowledge, again, just in orienting my thoughts and our thoughts to bring into the room virtually the thousands of people who have survived, or in too many cases not survived, the torturous experience of solitary confinement in its many names and guises in Canada. And along with those people, many of whom I've learned from in terms of them sharing their experiences with me, I also want to acknowledge a number of my teachers, people like the late Patricia Montour, now Senator Kim Pate, Australian feminist abolitionist lawyer Debbie Kilroy, and many others who have influenced my thinking, as well as the two panelists today and many others of my colleagues. The thinking that I have done owes a great debt to many people. Okay, the British Columbia Court of Appeal decision, and I should say, Adelina, please do stop me if I've reached my 20 minutes. I'm going to try to keep track myself, but please do just jump in and stop me if I go over. So this is a case, even the name of the case, BC CLA and John Howard Society versus Canada. There's no individual plaintiffs in this case. And this is a case like the one that Lisa Kerr is going to talk about, that is a public interest standing case. And that's, I just flagged that at the outset because that's really important, that the court, accepted this as a public interest standing claim. I'm aware of, and you may be aware of, some other cases in which courts have not allowed interest groups, advocacy groups, community groups to bring public interest, to have standing to bring up a public interest charter case. And one, for example, is around the mental health law regime here in British Columbia and the lack of charter standards in that. And I think that's a huge problem when courts are gatekeepers for these kinds of claims. Fortunately, this one went forward. There were some other intervener groups at trial, West Coast Leaf, the Criminal Defense Advocacy Society, and then a number of other interveners when it went up on an appeal. So it had the benefit of a lot of different voices. The charter claims. Okay, so what was being argued here? Well, the essence the essence of the claim was Section 7 of the Charter, which is the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with principles of fundamental justice. That was one of the key charter claims that was said to be breached by the administrative segregation regime. Section 15, which is the equality guarantee, the right to equality before and under the law, the right to equal protection, equal benefit of the law without discrimination, and in particular without discrimination on a number of enumerated grounds such as sex and race and disability, and analogous grounds like sexual orientation. Here, what was pleaded was discrimination on the basis of race, Aboriginality in terms of the disproportionate impact of segregation on Indigenous people who are incarcerated, and disability, mental disability in particular, the disproportionate way that people with mental health issues are segregated and isolated in various forms. Note that sex was not pleaded. Gender was not pleaded. It was not a basis on which the case went forward, although it does feature in the case. And I'll say more about that in a minute. So the evidence at trial, it was voluminous, right? This is a really, like, for those who are not sort of familiar with how litigation works, this is an incredibly labor-intensive case to bring. There's lots of witnesses. It's actually very, very difficult to mount a challenge like this. So there were 28 witnesses who were cross-examined on their affidavits before the court. Leading experts from the US, such as Dr. Stuart Gracia and Dr. Craig Haney, who have done extensive research on the psychological and other health impacts of solitary confinement. The government tendered their own expert witnesses. There were lay witnesses, so people with experience of surviving solitary confinement. There were CSC employees on the government side. In any event, something that's important to know, and to, if anyone's going to want to work with these cases going forward, is the findings of fact. And there are some important findings of fact in this case that were not disturbed on appeal. In fact, were not challenged on appeal. And those go forward as findings that have made by a court of law that you can rely on in saying, assessing what's going on in corrections now, and particularly when you look at the legal findings that are made in relation to those. I'm not going to go through all of them right now in the interest of time, but I'll flag for you paragraph 90 of the BC Court of Appeal decision. So the appeal decision later, when it went through and listed many specific findings of fact and law in the case, and findings of fact. And that's, I think, really important. Things like a finding of fact that administrative segregation as enacted at the time in the CCRA is a form of solitary confinement that places all Canadian federal inmates, is the language used, that's not language I use, incarcerated people, subject to a significant risk of serious psychological harm, including mental pain and suffering, and increased incidence of self-harm and suicide. The government had litigated this case on the basis that all that stuff that Professor Ifton was just talking about doesn't apply in Canada because we don't do solitary confinement, right? And the court cut through that, as one would expect and hope, and looked at the substance of what was being practiced and not what it was called, right? Nobody's, in fact, I'm not aware of any prison authority or other government agency that practices solitary confinement calling it, in fact, that. But in any event, the key findings of fact were around the indeterminacy of administrative segregation being particularly problematic and harmful. That while some people suffer particular harms, all incarcerated people are at risk of experiencing harm. That the negative health effects can occur after only a few days in segregation. So this 15 days is, the court said a defensible and important international standard, but it is not determinative of when practices of isolation become harmful, and in fact, I would argue unconstitutional. And there's more. And I mean, there's findings of fact around that a finding of fact that CSC has on the evidence shown an inability to fairly undertake the review of administrative segregation decisions. So the need for external oversight, for example. There's a whole range of other findings of fact that I'm not going to go into now, but I'll sort of allude to as we go along, and we can discuss more. In terms of the legal findings, okay, so I mentioned those different provisions of the Charter, Section 7 and Section 15. There were also claims made under Section 12, cruel and unusual treatment or punishment, and Section 9, arbitrary detention. I'm not going to really focus on those because the court actually did not find that those rights to be breached, or didn't need to decide it, or there's a whole range of ways that the court focused on Section 7 and Section 15. But it's important to understand what happened around Section 7. There you always, and my law students always know this, and I see a few of you in the participants, you always have to show two things when you're proving a violation of Section 7, that one of the interests protected is deprived, so life, liberty, or security of the person, and then that it's contrary to some principle of fundamental justice. And those are specific articulated legal principles. And here the court found that, in fact, life was at risk, life was being deprived, people die in solitary, there's a risk of death in solitary confinement, or these forms of administrative segregation. And security of the person is deprived. Very substantial findings of fact, as I mentioned, around psychological and physical harms. And so you've got that triggered, and then you have to decide whether that's contrary to principles of fundamental justice. Well, there was a number argued, and I don't want to get into too much of the doctrine here, but what the court found was that the law was contrary, the practice of administrative segregation set out in the law, and as it was being practiced on the ground, was overly broad in terms of depriving people of their life or their security of the person in a way that overreached and did more. It had more of a negative impact than it needed to in pursuing its objective. So you're always looking at what the objective here is, and the objective that the court accepted was set out in the legislation is to maintain the security of the penitentiary and the safety of the people in it. The court found that it was overbroad in trying to pursue that objective. And then with respect to Section 15, the equality rights and discrimination part of the analysis at trial, I mentioned again that sex was not pleaded. Unfortunately, the trial judge made a finding on the evidence led at trial. I am satisfied that women are not disproportionately affected by the impugned provisions. I can talk a little bit more in the discussion if people want to about the problem of that. Fortunately, that part was actually overturned on appeal. but gender discrimination was not pleaded, notwithstanding there being significant evidence both in the case and that could have been put in, or that is actually quite well known, that women, there are ways that women are disproportionately affected, particularly Indigenous women and women with mental health issues, by the use of segregation, and that there are a whole range of ways that women's prisons themselves use isolation, for example, with people designated maximum security who are in de facto segregation, right, in many ways. So I have concerns about the fact that it was not pleaded, but and there was that problematic finding which was overturned. But what the trial judge did find was that there was discrimination on the basis of race, on the basis of the evidence presented in court. I'm satisfied that the impugned law fails to respond to the needs of Aboriginal inmates and instead imposes burdens or denies benefits in a manner that has the effect of perpetuating their disadvantage. Similarly, a finding of discrimination on the basis of mental disability. I'm satisfied that the law fails to respond to the actual capacities and needs of mentally ill inmates, is the language, and instead imposes burdens in a manner that has effect of reinforcing, perpetuating, or exacerbating their disadvantage. Very significant negative impacts on the evidence on people with mental health issues. Okay, so that, I'm just keeping an eye on my time. So that's the trial decision. And so then we had a declaration that the laws were invalid, that the administrative segregation regime was invalid pursuant to the violation of Section 7, to the extent that they authorize prolonged indefinite administrative segregation for anyone, that they authorize and in fact the institutional head to be the judge. This is the procedural fairness. I didn't actually talk about that, but there was a procedural fairness problem here, which becomes very significant when we look at the new law as well. The laws are only authorizing an internal review and not an external one, and they deprive right to counsel. And then there was the findings around Section 15. So what we had was in legal terms, a declaration that the law was invalid, but then because the court was persuaded that this is one of those cases where they should suspend the declaration of the impact of that declaration for a period of time because of concerns around public safety, rule of law. We can talk about whether we agree with those kinds of suspensions that are in my view, too often invoked in courts. But in this case, that was granted. So there was 12 months for the government to respond to this decision. Okay, so the aftermath now. That decision was rendered in January 2018. The federal government pretty quickly appealed to the Federal Court of Appeal. We had additional interveners coming into the case at that point. And then the government introduced Bill C-83, which we'll both probably be talking about, and which is the law now. This is the law that introduces the structured intervention units instead of administrative segregation. And I'll talk in a minute about some serious questions about its constitutionality. But that was introduced in October 2018. The appeal was argued in November 2018. The federal government could see that Bill C-83, because it was quite contentious and there were issues with its constitutionality that a number of us testified to, and that there was concerns about. It wasn't a smooth sailing through Parliament. The federal government sought an extension of the Declaration of Invalidity. They had to go back, in this case, to the Court of Appeal. The Court of Appeal did grant that to July 2019. But put some relatively rare, these kind of monitoring provisions in effect and certain conditions, which I'm not going to talk in detail about in the interest of time, but really concerned about the fact that we were going to have this unconstitutional state of affairs continuing. Summer 2019, the federal government sought another extension, which was actually dismissed, and there wasn't sufficient evidence filed. They were back in court on June 24th. The Court of Appeal rendered its decision. And let me just say a little bit about that. I already mentioned paragraph 90 of that decision, which has detailed findings of fact, which I urge you to familiarize yourself with. And they appealed the, they allowed the appeal in part. And that means that the Section 7 finding of invalidity still stood. That was upheld. The law was, in fact, in their opinion, invalid under Section 7. It deprived people of their life and security of the person in manners that were contrary to principles of fundamental justice. Prolonged indefinite segregation with the harms was overly broad. It was procedurally unfair with the only internal reviews. But they did invalidate, they allowed the appeal with respect to Section 15. And I don't have a lot of time to talk about that, but they, I think, so they said, in fact, the regime does not amount to discrimination against Indigenous people and people with mental health disabilities. But they, there's been a much more recent Supreme Court of Canada decision in a case called Fraser in Canada, released just in October of this year, which I think gives a much more robust clarification to the law of equality. And I think, I think if you want to study that, you can. My view is that suggests that the findings of discrimination should have stood if this would have gone to the Supreme Court of Canada based on the interpretation we saw from the majority of the court in Fraser. There was some other declarations by the Court of Appeal that the CSC had breached its obligations under the Act to give meaningful consideration to the healthcare needs of mentally ill and disabled inmates, that there needs to be a reasonable opportunity to retain and instruct counsel without delay, and that those had been violations of rights in the case as well. Again, the declaration of invalidity was upheld until, and it was later extended, until November 30th, 2019. Bill C-83 passed and received royal assent in June 2019, and then, as we're noting with this spotlight on solitary, came the regime with respect to structured intervention units came into effect in November 2019. Okay, Adelina, how am I for time from your counting? I didn't start my watch at the right time.
You have a couple more minutes.
Okay, let me just say this with respect to the new structured intervention units regime. There are no caps on time, and I'm sure Lisa's going to talk about the Ontario Court of Appeal decision that talks specifically about the 15-day cap. In the structured intervention unit regime, it's obviously described as a different, it's described not as solitary confinement, it's described not as administrative segregation. And in the whole process of it going through Parliament, the minister and the government took the view that essentially, because it's called something different and they've framed it in a different way, none of those legal rulings around constitutionality apply. Well, that's, in my view, not how it works with respect to constitutional rulings like this. There are findings of fact, there are findings of law that do bind, and the court will again be looking at the substance. And the substance is that this is not a meaningfully independent review, other than much later in the process. The layers and layers of internal reviews that someone who is subject to the SIU regime has to go through are incredibly, it's very hard to even wrap your mind around how many different layers of review they have to get through before they can get to this external decision maker, which doesn't even have the power to actually order them to be released. And for those reasons, I have been arguing, a number of other people have been arguing that that this regime is unconstitutional. It suffers from many of the same flaws that the earlier regime did, and that we need meaningful external independent oversight. when I testified before the House of Commons and Senate committee, my testimony was that, and I'm not alone in this, that the most significant amendment that could be made would have been to substitute the layers of review by various correctional and ministry appointed decision makers with a starting point that all placements in isolation, and that would be, defined, and it wouldn't be required to be only SIUs. It would apply to the fact and reality of isolation, are extraordinary and are generally prohibited. And then if a prisoner is placed in isolation for 48 hours, that would trigger an automatic review by the court, not unlike a bail review or other court reviews that are mandated by the criminal code. This is similar to what was eventually put in amendments by the Senate, which were rejected by the government. And in my view, what we've seen with the structured intervention units, with the recent report, which I commend to you, from Prisoners Legal Services about what's going on at Kent Institution, the report by Professors Tony Dube and Jane Sprott about what we see in the structured intervention units with people not getting their time out of their cell, some people being in there for 2 months or more. We are seeing the very problems that many of us, unfortunately, you don't like to be right about this, but that many of us had predicted. I think my time may be up. Is it, Adelina? Should I turn it over to Lisa?
Okay. I feel kind of bad to interrupt you because I love listening to you talk.
No, let's turn it over to Lisa. I want to make sure she gets her time. Sorry.
Yes. No, Lisa will definitely get her time. So I'm going to let Lisa talk, and we'll also have time for questions after that. Again, just a reminder, if you have questions, please start typing them in the Q&A box, and I will read them all at the end, and I will put them to the speakers. So we're all good there. Just make sure that you use that function. Lisa.
Thanks so much, Adelina, and thanks to Deb as well. It's wonderful to see each of you and to hear from you today. I want to echo Deb's acknowledgements at the outset, and also her thanks to our organizers today, John Howard, Canada, Canadian EFRI, Prisoner Legal Services. Thank you for putting these events together. It's a profoundly awesome and timely project, this 15 days of Spotlight on Solitary. It's an incredible list of people that are lined up to speak in the coming days, people who have been working on these issues for so many years and who don't seem to tire, notwithstanding the roadblocks and resistance and so on that we've seen from the prison service on this particular topic. I'm really glad that with this session, we have this chance to focus in on the court decisions. Like Deb, I'm going to get into the weeds of the Ontario litigation. I think it's really important for us to use these cases not only to assess how they might apply as precedent in future litigation, which seems fairly inevitable, but also to sort of learn in general about the promise and also the hazards of this kind of strategic litigation, to draw lessons from it, both for the prison litigation context and others. And my sort of general view that I want to emphasize at the outset is that I think the story here is fairly complicated. Even if you are a lawyer, and I know there's some on the call who aren't, it's a complicated story for all of us. It's complicated in terms of the specific legal claims that were brought in each jurisdiction, in terms of the specific evidence that was filed and accepted for those claims, in terms of the range of litigation strategies that were undertaken and the parties that were involved, and the ways in which the courts of appeal have both agreed with and departed from the trial decisions. And you heard some of that in Deb's presentation. So I think the solitary litigation in general is sort of complicated on all of those fronts. And then it's extra complicated because we get this new legislation before the case gets to the Supreme Court of Canada, which is pretty unusual. And then add to it that legislation seemed almost designed to address only the very worst defects of the previous regime, right? It seemed designed to do sort of the bare minimum to remedy the constitutional shortcomings of the old law. And I should say that, the initial bill that was tabled was worse than the final bill that was passed. And it really was many of the people who were on this call who are to be credited for the work that improved the bill. Kim Pate and Catherine Latimer, BC Civil Liberties, Alan Manson, Deb, Adelina, all of these folks did so much work along the way in terms of the legislative process to make the final version of the bill as better, at least than where it started. But all of that sort of story in terms of how complicated the litigation was and the fact that we didn't wind up with a Supreme Court of Canada decision was part of why it was quite difficult, at least for me, to figure out whether to support the new legislation and to figure out whether the legislation complied with what the courts ordered. Okay, so that's, the court cases are the focus of our session today. But I also want to say at the outset, something that is not, to me, complicated that has emerged over the past month or two, and that is the data that's been uncovered and analyzed by Tony Dube and Jane Sprott. It really makes clear in terms of how the SIUs are operating today, that there are constitutional breaches happening and that there is widespread legislative noncompliance. So that is clear. I think it's also fairly clear from the most recent report that they've offered us this week that the sort of COVID defense that CSC has suggested cannot fully account for nor fully justify the breaches that they've outlined and the degree of legislative noncompliance. But there is, of course, a panel on that set of issues on Monday, November 23rd at 5 p.m. And I know I'll be there, as many of you will be. Okay, so let me turn to the specific cases and specifically Ontario. And I am going to start like Deb did with the trial decision. In law school, we read a lot of appellate decisions, but it's always really important to understand what went on a trial because it very much shapes and constrains what's possible. And I want to be clear up front. My assessment is that the trial decision in Ontario was not great from a prisoner rights perspective. And I think many people, sort of in the town square and the public conversation are sort of confused or frustrated by the shortcomings of the new legislation of the SIU regime, because they say, how did we win in court and solitary is still happening? And I think part of the story, not all of it, but part of it is that the Ontario win at trial really was not much of a win. And while the appeal decision was better in a significant respect, it still sort of left the door open in a way to the new SIU approach. Then we had the government drop its appeal to the Supreme Court of Canada. And at the Supreme Court of Canada, we might have had a chance to sort of firm up and clarify the legal rulings below and with the benefit of, I'm sure, a range of interveners. At that stage, right, the stage in which the federal government drops its appeal, abandons its appeal, the headline was, the fight against solitary victorious because the government has given up the fight. That is not my take on it at all. The reason they gave up the fight was because they stood to lose at the Supreme Court of Canada level, and they saw the risks of what could happen there. So I think there were many downsides associated with not getting the case to the Supreme Court of Canada. I have no doubt that plaintiffs' lawyers involved in the cases well understood those downsides, but they really had little option but to sort of go along with the abandonment of the appeals. And they had this sort of awkward scenario where the case itself was about legislation that had been replaced. And the prospect of getting the court to opine on Bill C-83 on the new regime was quite an awkward one. Okay, so let me start. Now I'm really starting. Let me start by saying what I think the BC and Ontario trial decisions agreed on. I think both courts rejected the longstanding position from corrections that our prison system doesn't even use solitary. Both courts found that solitary can have severe effects on mental health, and that was contested to a degree by Canada's experts. It's kind of amazing that they were still contesting at that stage, but they were to a degree. Both courts declare that the current rules governing the use of solitary are arbitrary, unfair, that they violate Section 7 of the Charter, and the MNSEG laws are struck down on that basis. Okay, so those are the similarities in terms of the two trial decisions. And I think each of those are actually quite significant and had marked sort of a leap forward from where things had stood on these issues for many years and possibly even decades. But I think the differences between the BC and Ontario trial decisions are far more numerous and substantial than the similarities. So let me deal first with the procedural issues. And I'll just touch on the issues of oversight and access to counsel. So on oversight, both decisions discuss the need for greater oversight. Both emphasize that the current regime allows prison wardens to review their own decisions to segregate. The Ontario court calls this futile review, quote, an anomaly even within the context of penitentiary decision-making, end quote. So I take that to mean a slightly, cheeky remark, even within the context of the generally lame decision-making that goes on in prisons. This is a bad regime. The Ontario court does not, however, hold that the additional layer of oversight must be done by an independent or external reviewer. Instead, the trial judge or application judge says that CSC can do the extra review. And I think because of this aspect of the Ontario trial decision, that's part of why it was such a huge fight to get a robust independent review in the new legislative package. And at the end of the day, they did get independent review, but they did not get, as Deb puts it, a sort of robust external review with a power to release from SEG and so on. And of course, the legislation is designed and gets to third reading, before the Ontario Court of Appeal decision, so that what the legislators had in front of them was this Ontario trial decision that did not seem to require an independent form of review. And I want to emphasize that this part of the Ontario decision spans just 6 paragraphs. And in the only paragraph explaining this part of the decision, the court cites the interests of inmates and their need for expediency in declining to order independent review. And I'm going to presume that counsel for the plaintiffs didn't actually make that argument, right? But the court refers to it anyways, as though it's a sort of win for the plaintiff's side. And compare that with what the BC court does, which is spend 54 paragraphs or 14 pages discussing the history of calls for independent oversight of solitary and explaining in particular why the prison culture needs a truly independent check. And there's a simple explanation for the BC difference. Law professor Michael Jackson, Deb's colleague at UBC, really the leading person on this topic, filed an extensive report and testified in the BC case. He did not appear in Ontario. Second, on the topic of access to counsel, the BC court finds that the charter requires incarcerated people to be able to have counsel appear at segregation reviews. Now, this wasn't part of the Ontario claim formally, but it's worth noting that at paragraph 117 of the Ontario decision, the court seems to think that inmates already have the right to have counsel present. So the court in that paragraph refers to a provision that only says, if you look at the actual provision, that the inmate has the right to attend the hearing. There is in fact no provision at this time for counsel to attend at MinSeg reviews. And I point this out not because I think it's the most important part of the decision, but I think it's just sort of one indicator of a somewhat superficial appreciation of the law and policy that shows up in the Ontario trial decision. And I don't mean to entirely blame the court for this. I think this kind of thing can be a function of many things, including how the case was heard and argued. And a notable difference with BC is that Ontario proceeded almost entirely on the basis of written record with just a few days of hearing. The BC case took an entire summer with much more viva voce evidence. So let me turn away from those process issues to the issue of substantive limits on segregation. So everyone who had been working on these issues in the years of leading up to the litigation were very focused on 2 main issues. First, legislated time limits, right? Wanting a time cap. And 2, a categorical prohibition on segregating vulnerable groups like the mentally ill. And if you look back at the Arbor, the Ashley Smith inquest recommendations, those recommendations are right there. And of course, when the Liberal Party gains power, they say that's in the mandate letter to the Justice Minister to implement the Ashley Smith inquest recommendations. And of course, it doesn't happen. The view of these advocates, right, who were very focused on these two reforms, and I think this is absolutely correct, was that if we just sort of add a bit of process, right, without those substantive limits on how long a person can be placed in SAG and on who can be placed in SAG, that we would not effectively reform solitary, and we certainly would not abolish it. So that was a real focus, right? Now, let's look at what the Ontario trial decision does on those topics. It's interesting to see that the Ontario trial court does make many of the same factual determinations that in BC caused the court to conclude that the current system violates Section 15 because of its unequal burdens on mentally ill inmates, and that the charter requires time limits on admin SAG, although the trial in BC doesn't say exactly what those time limits should be. The Ontario court does accept much of the same evidence, right, that led the BC court to those conclusions. And much of the evidence is offered from prison employees. The Ontario court accepts that solitary has been abused, that it's created an aggravated mental illness in many cases, and it accepts, crucially, that a cap on segregation placements would be achievable, right? That in sort of a bureaucratic or institutional sense, that the prison system was capable of it, of operating with a time cap. But notwithstanding these and a number of related findings, the court declines to find that the legislation is invalid because it lacks time limits or because of how mentally ill people are treated and how they experienced segregation. Why? Well, it's a complicated thing that has to do with standing and remedies and a bunch of constitutional doctrine, but basically what the court does is apply a rule that says simply because a legislative scheme is open to maladministration, that's not a basis for striking it down, for declaring it unconstitutional. So what the Ontario court really seems to be saying here is this legislation doesn't mandate abusive amounts of time and segregation, and it does have some protections for people with mental health issues and so on that could be better applied, right? So the problem isn't that the law forces maladministration, right? It's a case of how prison officials are applying the legislation. And for that reason, the court declines a remedy in terms of a constitutional declaration. And it's partly connected to the fact that, as Deb notes, this is public interest litigation. Okay, that's kind of complicated stuff, but so I want to say that there are many other examples in the Ontario decision of the court almost stretching to find that the current regime is or could be acceptable. Just one example, at paragraph 259, the court begins the paragraph by noting that harms accrue as segregation continues. And the court accepts that initial screening mechanisms are faulty and don't prevent the segregation of mentally ill inmates. But the court goes on and says that the applicant hasn't shown that subsequent monitoring isn't effective. And the final sentence of paragraph 259 is this, quote, nor did the applicant suggest that the ongoing monitoring of inmates provided in the Correctional Service of Canada's policies would be unable to detect deteriorating health. And the grammar here is very awkward, and I think that is telling, right? The court is not convinced that CSC policies would be unable to detect deteriorating health. And I think that's a very strange way of describing the applicant's burden in a case like this. And it also presumes that CSC will respond adequately when they do detect deteriorating health and segregation. And I think a great deal of evidence filed in this case and in BC suggests otherwise. So I think the Ontario trial decision is in sharp contrast to Justice Leask's approach in BC. For Justice Leask, the question is not whether, in theory, the law could be properly administered, but whether the legislation contains sufficiently concrete limits for a practice that is so vulnerable to excess and abuse. And I'll note here that the Ontario Court of Appeal does overturn the application judge on this issue of maladministration and the remedy. But again, I want to point to it just to say, sort of say what the vibe of the trial decision was. So Deb also described how the BC trial court finds that solitary violated equality protections because of its disproportionate impacts on Indigenous people. The Ontario decision does not mention Indigenous people. The case simply wasn't brought that way, and that evidence was not put before the judge. And a final point along the same lines is about the lack of inmate voices in the Ontario case. As far as I understand, there were 3 inmate affidavits filed, but the only reference to inmate evidence is at paragraph 139. And there, the reference is very strikingly to me, it's not to evidence about their experience under these laws, not about what it was like for them to be segregated and so on. Rather, the court mentions only the criminal records of the 3 affiants. So the evidence is cited only to make the point in a sort of almost implicit kind of way that prisons are full of very difficult people. Almost to sort of say, hey, they all have criminal records, right? Which, is a little obvious, but even under the section 12 analysis, right? So the cruel and unusual punishment analysis, there's no reference to the evidence of any person subjected to the practice. And that's very striking, of course, because this idea of cruel and unusual punishment is really about the experience of it, the phenomenology or the lived reality of it. And I remember way back when studying at UBC with Michael Jackson, and in talking about litigation strategy under section 12, he was always very clear that you had to hear from people, right? That you didn't want to file, just a written record, that the judge needed to hear from people, their experiences, their voices, their actual sort of corporal sort of presence and so on. And I think that really comes out with what happened here. And in contrast, inmate evidence really appears throughout the BC decision and is used not only to describe qualitative experiences, but also to resolve legal issues. And I'll point you just to paragraphs 399 to 410, where you had the evidence of an incarcerated person named Blair, who experienced 79 days of segregation for basically totally bunk reasons. And then that you see the warden who reviewed the segregation, right, basically reviewing his own decision over and over again. You see the circular and arbitrary reasoning that's employed. And that was relying on the evidence of Blair to make that, in order to depart from what the court did in Ontario, which was say that the review could be internal. Okay. Okay, let me turn now briefly and to conclude with the Ontario Court of Appeal decision. So what did ONCA do? I'm going to just take you right to the important part. There's some few other bits in here, but this is really the crucial bit. The main thing that Justice Bonotto does that's different from the application judge is she does find a section 12 breach for any solitary that extends beyond 15 days. Think back to that slide that Adelina had up about prolonged solitary beyond 15 days. She says that that does violate section 12, which is, of course, the prohibition on cruel and unusual punishment. And she really is just relying on the findings of fact of the trial judge, right? That's what courts of appeal have to do. They're stuck with the factual record. But she's able to point to the factual determinations at trial and say there are severe effects from prolonged segregation. And the harm is not always quickly or easily observable. And monitoring is often only able to respond to decompensation that has already occurred. Now, I think Justice Bonotto, although she's following some settled law on this, I think she has a kind of funky way of thinking about how to detect cruel and unusual punishment in a prison conditions case. And I have a paper on that with Ben Berger in the Supreme Court Law Review. I think it's called something like the 2 tracks of section 12. So I don't exactly like the approach taken, but the bottom line is that she does find that the harms that flow from solitary beyond 15 days are cruel and unusual punishment. And she notes that while the law says that to release an inmate at the earliest appropriate time, it's clear that this could well be and has been in hundreds and hundreds of cases well after 15 consecutive days. Okay. And she, of course, overturns the application judge and says the legislative safeguards are inadequate. So that's a constitutional problem. It's not just a problem of maladministration. So this has led many to say, and I'm sure this is what we will talk about now in Q&A, many to say, well, what the heck? the Ontario Court of Appeal said there has to be a 15-day cap. So how is it that we have solitary now going beyond 15 days? One answer is about, it didn't get to the Supreme Court of Canada. It's an Ontario decision. And I do think actually that the decision has been sort of heard within provincial corrections in Ontario, and that they appreciate that that rule applies to them, and that they can't do this practice, whatever it's called, of solitary 22 hours or more in a cell beyond 15 days. So that's kind of the good news, is that I sense, although maybe people on the call will tell me otherwise, that provincially within Ontario, there's a sense that that rule does apply to them. And here's the really tricky part about assessing the new legislation, and Deb mentioned this as well. The new legislation, the 15-day time cap technically applies to the practice that Justice Bonotto, the Ontario Court of Appeal, had in front of it, which was, 22 hours or more. And in fact, the legislation it had in front of it had zero time out of cell that inmates were entitled to. As a matter of policy, they were entitled to 2 hours out a day, but the legislation they were adjudicating actually didn't mention a thing about any entitlement to time out of a cell. The new legislation, Bill C-83, does set out this entitlement to 4 hours out. And 2 of it is supposed to be meaningful social contact. And I think everybody involved in these issues was immediately worried about enforceability, what that would look like, access to justice problems, oversight problems. But I think as a matter of sort of technical constitutional doctrine, the 15-day time cap does only apply to 22 hours a day. And the government, read the decision carefully and took the position that the 4 hours that they were providing for under the new legislation transformed this practice and made it something different than what Justice Bonotto said was had to have a 15-day time cap on it. So I'm gonna stop there, and hopefully we can have some discussion.
Thank you very much, Lisa. I want to encourage people to type questions if they have. So in the Q&A, we already have 2 questions from somebody, which I'm going to read aloud because I don't think the audience can see them. Before that, however, I just want to mention I have just one quick comment. When I was kind of pleasantly surprised to hear, Lisa, that the Ontario authorities tend to have taken sort of the decision to heart. And they tend to sort of apply that limits to provincial prisons. I'm not familiar at all with what's happening there right now, but it's very unfortunate because in Nova Scotia that's not the case at all. So I think, again, obviously there are very significant variations, and of course this was a case from Ontario, even though it was talking about an Ontario case talking about federal legislation, so it had nothing to do with Nova Scotia. But that said, we do see very, very various forms of isolation, and my guess is that probably in provincial is probably even harder to take account of them than it is in the federal prisons, simply because there is not much oversight over provincial prisons in many parts of the country, right? So I think that's probably that remains probably quite problematic. Okay, so let me read the question that, I see also somebody has their hand up. Okay, well, I'm going to read the questions first. So somebody asks if you could speak to what you think might be the government's rationale for rejecting the Senate's recommendation for external review. And I know Lisa touched a bit upon it, so I'm gonna ask Deb to answer that.
Yeah, thank you. Well, it was for judicial oversight, right? Not sort of, that's one form. There's different ways you can have external oversight, but this was actually to have to go before a judge. And well, I can't know their motives, but probably because some people were telling them that other forms of external review would be constitutionally okay. Also because there's no question that going before a judge is not something that the government is going to want to subject their practices to judicial oversight in this context. I don't think they've been resistant to all forms of external oversight, and judicial oversight would be the most kind of, again, there's no guarantee the judges are always going to find that, it's unlawful or anything, but but just that they're more in the business of adjudicating liberty and those issues than are other forms of external decision makers, or internal, certainly for that matter. I did want to take a stab at the second question too, Adelina, or do you want to open that up to maybe to both of us?
Yes, please do, and read it out loud.
There was another question about what recommendations do you have for charter-based advocacy challenging solitary confinement in all its forms? And I'd love to hear Lisa on this too, and you, Adelina, as well. But I'll just say this. First, I think this battle that we've been talking about in the courts and trying to bring some accountability and to really end, I mean, I believe we need to be ending this practice of solitary confinement, and we need to ask for more, right? I mean, sometimes, and I don't suggest it's easy, and going to court, we can't be going to court for all these things all the time. We can't do massive charter litigation, but I think in our demands, both in court and of our legislators and in our advocacy, I really think we should be pushing for more than what we think we're going to get, right? Because we're always going to be pushed back. I mean, there's much research to show carceral clawback. So even when you have some, new reforms or things that sound great on paper, that the way that carceral institutions are is these are institutions that are all about caging people and depriving people of their liberty, and they are very resistant to fundamental human rights. I think actually they're quite inconsistent with notions of human rights. So you're always fighting, and it's going to be kind of a shape-shifting, new names for these practices if the old one is found to be unlawful, which is exactly what we're seeing. And it's a game of whack-a-mole, right? And you kind of have to go in aware, from my perspective, go in that and not expecting that it's going to kind of come to us in terms of those changes. So I would say seek fundamental change. I mean, I put my cards on the table. I'm a prison abolitionist. I think that we need to be advocating for not advocating for solutions that are actually building up or putting more resources into incarceration, that the resources that are now being spent on the SIUs ought to be spent on decarcerating and getting people into the community. Indigenous people are still much more likely to be in long past their parole eligibility dates. They go to warrant expiry, they go to statutory release. This is unconscionable in our country when they're also the same people that are being held in SIUs. And so I would say, we're talking about defund police. I would say defund corrections. Look at at our strategies to be much more anti-carceral. And I realize that is a horizon, but I think it's a useful horizon to be bringing to our work.
Thank you. I'm just gonna I'm gonna be very brief because I see a lot of questions either through raised hands or in the Q&A. I want to echo basically what Deb has said and agree that, and as you've heard from Lisa's presentation, litigation can be very, very messy. And I think it's questionable, while it can be a good tool to deal with certain specific issues, and it is quite an unfortunate state where we've gotten to the point where the only way it appears we can change anything is by taking it to court and challenging it through charter litigation or anything of that sort, because of the very significant problems, as you can see with these particular two cases, of implementing the decisions, because of the jurisdiction issues, so you cannot really expect swiping reforms and changes that are coming out of one single case. I think that ultimately they will have to come from higher up. They will have to come through legislative reform, and not legislative reform, as Deb has noted, that is incremental and just changes the name of one problem with another, right? So if you think of where we are now in comparison to where we were last year, I'm not sure we're in a much, much better case, and we are, two charter cases later, one massive legislation reform later, and I question if the people that would have experienced the various forms of isolation over the last year would think that we are doing much better right now. So I'm just gonna stop there. But yeah, I don't know if Lisa wants to add anything to that.
I know we are short on time. I see Kim Pate's hands up. I'd love to hear from her.
Okay, then Kim, do you want to? Oh, I have to give you permission to come up and speak, I think. Oh, I'm in the position when I have to give Kim Pate permission to come up and speak. You have to love that. Where is it? Okay, there we go. Kim, you're going to have to unmute yourself and you can ask. No? Oh, maybe it's there are two Kims. Okay, there we go. Now.
There we go. Okay, sorry, can you hear me now? Yeah.
Yes.
Story of my life. I can't figure out technology. Thank you very much. I'm sorry that I missed your presentation, Adelina. I was coming in late from another meeting, and I wanted to pick up on and ask each of you a question, as well as those who are attending. I was tempted to leap in about Senate, what happened at the Senate, but I'm doing a presentation, so I can talk about that hopefully then. But when we talk about viva voce evidence, I absolutely agree with what Lisa said. But one of the challenges that I've found over, nearly 4 decades of doing this now, is that too often the listening is only a parroting of what people say and not an actual integration of the skills. And what I mean by that is rarely do I see lawyers going in and saying, look, here's an array of options available, but really what is the objective here, and challenging people to think more expansively about their situation. And that's part of how the remedies that some of us have gone for have been way out, more expansive than the ones that the courts or that these two cases took up. Because when you talk to individuals, mostly what they want to be is not in segregation, not in prison if possible, and yet the remedies that are provided, or the remedial options provided by lawyers, are often far short of that, and individuals, whether they're imprisoned or in the community, are often told that can't work, we can't fight for that, when in fact it's not true. And I use the example here in Ontario, for instance, of a number of folks who wanted to fight similar to some human rights fights we were doing federally. And they were told that the only thing they could go for was to actually have, a handbook in segregation, or not to look at actually ending segregation or judicial oversight or any of those sorts of things. And so I'm curious as to, what each of you has thought about that this is an iterative process. It's not merely going and based on the limited options available, or that prisoners think are available, following that option, either of a limit to seg or any of those things. And it's part of how we ended up, after the inquest into the death of Ashley Smith, of both a homicide verdict, but also a call for the end of segregation for women, for those with mental health issues, and increasingly for Indigenous prisoners as well. So I'm just curious as to what each of you thinks about that.
Well, maybe just one response. One response. I thank you, Kim. Nice to hear from you. One response might be to connect to, there's a question in the Q&A from Ahmad Talisman, and he says, he's self-effacing here. He says, I'm not a lawyer, so I'm naturally I'm confused. If the SIUs are failing to meet their legislative obligations, are they not breaking the law, and so on? Who makes this determination? And does it have to occur through litigation? And just to connect Ahmad's question with Kim's, law is not self-enforcing, right? And you constantly have to assess, as someone who works in this area, how to bring a claim. When in my year at Prisoner Legal Services, where I learned so much from Jennifer Metcalf and other colleagues there, I feel like that's all we did, was have meetings about how to bring a claim. Should it be human rights? Should it be charter litigation? Should it be class action? Should it be civil? Should we use the grievance system first? This is really what prison lawyers and I think other, immigration lawyers, others are obsessed with, right? And we're constantly just, I really take Kim's point about, you have to think about transformative change and transformative remedies, and not just keep the frogs in the pot as the water becomes boiling. Without, you all know that metaphor. And I think we're constantly having to ask ourselves, what is achievable in court? What is winnable? what is futile, what could have unintended consequences even if we do win. And there's a huge literature on that in prisoner litigation, the literature on unintended consequences, ways in which wins in court have served to solidify the prison system, attract resources to it. And Kara Matt-Ryder has a book on how that happened with supermax prisons in the United States. And you know, and then some of us have like conservative personalities, and then we're constantly inspired by people like Kim Pate who push us to think about a more transformative approach. And so I think that is just kind of part of doing this work.
Yeah, I mean, I do think that I mean, I've written a little bit about how I think we should bring, or those of us who take an abolitionist, who are persuaded by what's been going on around defund police and abolition, and I mean, I learned to be an abolitionist from Kim more than 20 years ago, and from a number of other people that have been my teachers in that. But it's much more in the public awareness right now, and I think that this is a moment for us to be more bold in what we are doing, and I also think to connect litigation to social movements more, and to be, and I think there's some of that going on, but I think we could do much more. And by social movements, the abolitionist movement, the Black Lives Matter, the Indigenous anti-colonial land back movements, and being more connected to those kinds of struggles, I think can help those of us who are lawyers who, we do think, okay, what are we often don't ask for too much. We don't push it far enough. And I'm looking at myself in this. I'm not like, oh, I have all the answers. I'm really saying, this is something that I'm wanting to challenge myself on. And I'm not someone who's actually on the ground doing the work. I'm teaching, and I support litigation and have done that over the years. But I think bringing a prison abolitionist lawyering ethic and thinking about more connections between litigation and social movements is part of this, right? I think, and it's part of the way forward. And there's some of that really exciting work going on in the US. If you look at the transformative justice and abolitionist work where lawyers are involved in that in the US in ways that I don't think we have done as much here. And I think we're in a moment to do that more.
Okay, I'm gonna move to, because we received a set of, we received 4 questions. So we are really tight on time. So I'm going to try to go through them as much as we can. There is somebody who's asking, Jessica's asking 3 interrelated questions. I'm gonna take question 2 and then leave question 1 and 3 to Debra and Lisa, unless they prefer otherwise. So question 2 asks, why do you think the federal government abandoned their appeal of these decisions in May of 2020, months after the amendments to the CCRA came into effect? And I'm going to give you my very cynical answer, because I don't know any way differently. So I think that was interesting, and I think a lot of us, and Deb and I wrote a piece in the Vancouver Sun together with Kim Pate at the moment in response to their decision to actually abandon the appeal. And it was a very cynical piece, because the timing was indeed interesting. So if it would have been motivated by the fact that they realized that the issue was moot, or they would arguably have done that way before that, right? Before May of 2020. But I think there was strategically, and I think it was actually April 2020, and it was actually, I think, a very smart, in my opinion, a very smart strategical decision. One of them was that probably things were not looking particularly good. There may have been some of concern as to what the Supreme Court might have said. So there may have been some response to that, I think. But I think there was also another issue, and that was COVID. And there were, at that particular point in time, in March, April, there were significant, we were 3 weeks, I think, into the COVID pandemic when they announced that they are going to drop the appeals. And there was massive, massive, massive amounts of pressure from all interest groups, from advocates, from basically everybody that I know that works in imprisonment, to actually start decarcerating people very seriously. The federal government have been called out significantly on that. So there was a lot of backlash. Media was doing more work than I've ever seen them doing in this field. So there was a very significant engagement and concern for the well-being of incarcerated people at the point in time. And what does the federal government do in response to that? Nothing. What they did do was to say that they are dropping two appeals of two cases months after the issue, completely unrelated. So I think that in addition to some concerns as to what the Supreme Court said, this was also a very self-serving move on their side to distract attention from what was going on, I think. So yeah, that's my cynical response. I don't know if one of you wants to add to that, or Jessica is also asking if you think the amendments to the CCRA via Bill C-83 technically and sufficiently responding to the BCCLA and CCLA decisions, EI repelling in name administrative and disciplinary segregation and replacing with SIUs.
I think not, and I think the evidence that that has been coming out through Tony Dube and Jane Sprott's report, and as I mentioned again, the PLS report into what's going on at Kent with the SIUs. I think some of us sadly predicted it was a change that people aren't getting their time out of cell. It is experiences of solitary confinement, and that's just the SIU units. Let's also remember that there are other names for forms of observation units and other ways that people are isolated in federal corrections that again, and this is the challenge of litigation. So I look to the really smart minds on the strategic side of how you actually do this. Like, can you go to court and get some kind of declaration? Is there some way that we could be moving this forward? And if nothing else, certainly shaming the government for doing this, I think, because we simply have an unaccountable system right now when the law can come into force, and then there's this review body set up for it. They don't get the documents, and then when they do get the documents, the data about what's happening with the SIUs, it proves to be deeply problematic. And I'm grateful for the work that people like Tony Dube and Jane Sprott are doing, but we need to figure out what we can do with that to kind of push this forward.
I might just add to that on Jessica's question one, that it's really not unusual to see a government in power sort of respond to a court decision by doing as little as possible to address a constitutional defect. We've seen that, in recent years done by both conservative and liberal governments, whether it's on the sex work file or it's on physician-assisted dying or solitary. And so this is kind of not unusual, and we shouldn't be too sort of shocked by it. It's kind of what governments do, especially when the resources and the politics are rather uninviting on particular issues. I think I'm probably a little bit more thinking that it's a bit of a close call, whether the precedents that exist now make clear, but it doesn't really matter, what I think. What matters is like what a court's going to say about it. Right now, it's good law until we go to court and win a case. It's a great case. I would take that case. There's lots to say in favor of the argument, and there's lots of evidence to file that the new legislation does not meet the concerns of the courts in BC, at least. But I think the Dube-Sprott data really make clear that CSE is not following the law, right? We know that, that's for sure in a huge number of cases. So they're in a legislative non-compliance situation, but is the legislation itself unconstitutional? I think that is actually a different question than the one that the Dube-Sprott data addresses.
Okay, thank you. So somebody says here, and I mean, that's, after Lisa has just said that she is not sure that the legislation is unconstitutional, somebody asked if, given that the new regime arguably remains unconstitutional, where does that leave us from an advocacy perspective? Yeah, I think we're going to end with this question, and regardless of whether, the regime is unconstitutional or non-constitutional, I think that it remains deeply problematic no matter of the reason. So I think it's a good note to ask, what do we do now moving forward from an advocacy perspective? So I'll invite each of you to maybe say a couple of words before we conclude.
Well, I think I've said I think I've maybe spoken to that already. So like, I do think, you know, connection to social movements, anti-carceral, like trying to think about ways to divert resources to ask for remedies that are about getting people into community, you know, supporting the work that is being done to kind of call attention to this. I think there's a lot we can do at a practical level. You know, I'd like to, you know, hear from more of the kind of constitutional litigators about at a practical level, is something we can do to go to court on this, short of a whole new case. The other thing I just would say though is that there's lots of other ways that that we can have courts rule on these issues, including in sentencing, in habeas corpus matters. There's a lot that actually can be done, and that particularly for the lawyers in the room or in the virtual room, where we can argue to have people released from these kinds of conditions, right? And that we can have courts make statements, declarations, findings about unconstitutional conditions of confinement that I think then can go some distance in this fight.
And I think there is also something to be said about the fact that there are other types of advocacy outside of legal advocacy, right? And pushing for changes through the parliament, pushing for changes through other means are equally good and probably sometimes even more effective. And I would say, you know, where I stand from my point of view after, you know, seeing where we have ended up after a year of SIUs, I would say it's either time to, you know, if we're not going to do away with, you know, a clear ban on all types of isolation, which I would personally prefer, and I think that's, you know, what we should be pushing for, then perhaps we need to go back to the drawing table on what a Bill C-83 did and maybe reconsider in light, maybe now we're going to be more amenable to the Senate's amendments at the point in time, and perhaps consider that it is time to talk about judicial oversight. It is time to talk about a hard cap. And it is time to actually engage in a more meaningful manner with the various concerns that were raised, as opposed to say, oh, well, we're just going to do better at implementing the SIUs because, you know, the legislation might not be that bad. So, yeah, that's my take on it. I don't know if Lisa would like any last words.
Oh, so much, so many last words I would like to have, but I am very aware of the time. I would just say, you know, a couple of months ago, we had no idea what was going on inside these units. We didn't have the data. I didn't anyways. You heard stories and had hearsay and so on. And now we have a couple of good reports, courtesy of our colleagues. And so now I think the move is, you know, pounding the table about non-compliance. You know, we've seen sort of the class action space be very successful on solitary in recent years. And so maybe that's the place to go with it, right? And I agree completely with Deb that there's other places in the legal system that we have to keep in mind and think about. Judges in lots of cases are responsive at sentencing to concerns that someone's headed to solitary or that they've spent significant time in lockdown in the pretrial space. So defense counsel needs to be making those arguments, but we also need to be turning our mind to topics beyond solitary. Solitary is hugely important, but so is the total lack of access to post-secondary educational materials and the internet, and especially during COVID. There's lots of other issues, and so I think we need to, you know, keep our eye on this ball, but also sort of see if we can mobilize attention to other prison issues as well. After, you know, solitary really has had a lot of attention in recent years, and we need to build on that.
Thank you so much, Lisa and Debra, for your amazing presentations. And thank you everyone for attending and staying way over time here. And please make sure that you go back and you watch the sessions from yesterday and the day before. Make sure that you tune in for the next events. There will be one event every day. So keep an eye out on that. Thank you for being part of the conversation. Have a good night, everyone.
Thank you, Adelina.